Hi, everyone, and welcome. Today, we're going to follow the story of a legal claim, a journey that kicks off with a simple unpaid bill and wraps up with a judge's final decision. We're going to walk through the key steps of the county court process here in England and Wales, so you'll know exactly what taking someone to court really looks like.
So let's just imagine for a second, someone owes you money. Maybe you're a freelancer, maybe you run a small business. You've done the work, you've sent the invoice, you've sent the reminders, but the payment? It just never shows up. You say, that's it, I'm taking legal action. But what does that actually mean? What happens next? Well, let's dive in.
Okay, so first things first, before you even dream of filling out a court form, the system actually forces you to hit the brakes and follow some really specific ground rules. You see, the courts view a lawsuit as the absolute last resort, never the first move.
And the reason for that all comes down to this one big idea, the overriding objective. Now, this isn't just some nice-sounding phrase. It's the guiding philosophy for the entire civil justice system. Every rule, every form, every decision a judge makes is all about handling cases fairly and at a cost that actually makes sense for what's at stake. It's all about being efficient, being fair, and trying to get people to settle if they can.
So, how does the court make sure you're taking this seriously? Well, with something called the pre-action protocol. You can't just sue someone out of the blue. You have to send a very specific letter before claim, include some standard court forms to help them reply, and then, and this part is absolutely crucial, you must wait 30 days. If you jump the gun and file early, the court can penalize you for it later on, even if you win your case. So, let's say you followed the rules. Those 30 days have come and gone, and still, nothing. No payment. Now, you're ready to fire the starting gun. This is the moment your private disagreement becomes an official case for the courts. And it all starts with this document, the N1 claim form. It might look a little intimidating, but every single section is critical. You have to get the names right. That's you, the claimant, and them, the defendant. Then you write out the particulars of claim, which is really just a short, clear story of what happened. You state how much you're claiming, add on any interest you're owed, and finally, you sign a statement of truth. That's a serious, legally binding promise that what you've said is true. And that little stamp from the court, that is the point of no return. The second the court issues that N1 form, the clock starts ticking, loudly. What was a private argument is now a formal court case, and that triggers a whole set of strict legal deadlines for everybody. So the claim form gets sent out. Now the ball is officially in the defendant's court. They've received the papers, and they have to make a really important and very time-sensitive choice about what to do next. And when I say time-sensitive, I am not kidding. From the moment they get that claim, a defendant has just 14 days to respond. That's it. And doing nothing, that's the absolute worst thing they could possibly do. It allows you, the claimant, to ask for something called judgment in default, which basically means you win automatically without them ever getting to tell their side of the story. So the defendant really has three paths to choose from, each with its own form. First, they can acknowledge the claim, which is basically a smart way to just buy more time, extending their deadline to 28 days. Second, they can admit the claim if they know they owe the money and maybe want to suggest a payment plan. Or third, they can defend it and formally start a fight. And in our story, this is exactly what happens. Buildwell Construction files a formal defense. They don't just say, we don't owe it. They give their reasons. They argue that the report they were billed for was so bad it was basically worthless. And just like that, the battle lines are drawn. You know, once a claim is defended, the dynamic totally changes. The court steps in and takes active control. It's not up to you or them to decide what happens next. The court becomes the project manager, and it lays out a very clear path to a final hearing. So the first thing a judge does is assign the case to a track. Think of it like a path. For smaller claims, say up to £10,000, it lands on the small claims track, which is pretty informal. But bigger claims go to the fast track, or for really large complex cases, the multi-track. And this decision is so important because it dictates the rules, the schedule, and maybe most importantly, how much of your legal fees you can get back if you win. To figure out the right track and the timetable, the court sends everyone a directions questionnaire, or a DQ. This is your chance to tell the judge what the case is all about. How many witnesses you have, if you need an expert, how long you think the trial will take, the whole shebang.
Based on those answers, a judge issues an order called directions. This is the official timetable for the case. It sets out a bunch of strict deadlines for things like exchanging all your relevant documents, swapping signed witness statements, and eventually it sets the date for the trial itself. And as you can see, that can often be many, many months down the line. All right, so after months of prep, swapping evidence, and hitting all those court deadlines, we finally arrive at the main event, the final hearing. This is where a judge listens to both sides and finally delivers the verdict. If you win, the court issues a county court judgment, or a CCJ. That's the official order that says the defendant, who's now called the judgment debtor, legally owes you the money. But, and this is a huge but that catches so many people out, winning the case is one thing, but it doesn't mean the money magically appears in your bank account. Which, of course, leads to the most important question of all for anyone who's won a case. What happens if, even after losing in court, the other side still refuses to pay? Well, this is where you have to move from winning the case to enforcing the judgment. It means you have to go back to court and ask for special powers to actually collect your money. The right tool really depends on the debtor's situation. If they have valuable things like a van, a warrant of control can send in the bailiffs. If they have a regular job, an attachment of earnings order can take the money directly from their salary. And if they own a house, a charging order can secure your debt against their property. So, there you have it. From a simple letter all the way to instructing bailiffs. That's the real journey of a county court claim. It's a structured, powerful process designed to resolve things fairly. But seeing the time, the cost, and all the uncertainty involved, it really leaves us with one last question to think about. Even when you know you're in the right, is starting a court case always the right decision? Something to chew on. Thanks for watching.